2026, 9 a.m. Bob, continue.
Thank you.
Thank you. Court calls case People versus Malik Robinson.
Good afternoon, Your Honor. Raymond.
Good afternoon, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Robinson, who's present.
Good afternoon.
Good afternoon, Judge.
I'm doing okay. Your name?
Malik Robinson.
Thank you.
Hey, before me, a plea form. Is that what we're doing today?
Yes, Judge.
All right. Plea form indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed and the sentencing judge waiver is checked. That's the court's full understanding of the agreement.
Chairman, that is accurate. We'll just add as part of a resolution that involves the defendant's other case. He's waived up on that one. And you can fight up on that. I didn't put down the form because it's a different case, but it's part of it.
But he's not seeking HIDA on this case.
He's not HIDA eligible.
He's not, I got it.
3 days past eligibility. Just had a birthday.
Got it. Okay. All right. Let's have him sworn.
Raise your right hand. Do you solemnly swear in the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Malik Robinson.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a first responder. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of January 2nd, 2026, at the location of 2749 Adrian Drive, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
Yes, Your Honor.
What happened?
I was told some rules. I was given the order and then followed
Okay. What order were you given?
to leave the premises.
Okay, so you weren't supposed to be there?
I was. I was coming to grab my things.
Okay, so let me ask you this. Why was the officer asking you to leave?
Your Honor, the officer was asking him to leave so that things would calm down. To leave 2 hours for at least 2 hours or 24 hours.
Okay, so that's, I suppose. So at your home address, the 2749, that's your home, right?
At the time.
Not anymore. At the time it was.
At the time it was, that's right, okay. Something was happening in the household between people in the house. That be
Yes.
fair?
Yes.
All right. One way or another, police get called,
Yes.
right? And they give you a lawful order to try to diffuse the situation, telling you to leave the premises.
Yes, Your Honor.
And you would agree that that would have been a lawful order or command on their part, given the circumstances.
Yes.
And you refused to do that.
Yes, Your Honor.
And so when you refused to do that, what happened? Yeah, not a good thing, huh?
Yeah, not a good.
Yeah, it didn't work out for you, did it?
Not for real.
It would have been better just to listen.
Yeah.
Yeah, okay. All right. Sir, if I accept your plea, you want, and you knew, I should ask you, you knew that they were officers acting in their lawful duty, acting in
Yes,
their
sir.
lawful. All right. Sir, if I accept your plea, I do have to advise you that between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined in the Michigan court rules, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
March 17th at 9 a.m.
March 17th, 2026, 9 a.m. before Judge Garwood. Bond will continue. All right. Thank you, sir.
Thank you,
Judge,
Your
I
Honor.
just wanted to make sure.
Oh, I don't have another date, so you.
Okay, so I'll pick it up with them. Thank you, Judge.
Thank you. Court does call the case. People versus Rita, is it Gittick?
Good afternoon, Your Honor. Steve Tremontin with and on behalf of the defendant, Dr. Rita Giddick. Dr. Giddick, could you state your name for the record, please?
My name is Dr. Rita Gittick.
All right, thank you. What are we doing?
We're asking for an exam date, Your Honor. Discussed March.
Discovery is complete.
Correct. I have not been informed that there's any discovery they have that I don't.
And would people have their witnesses available the third?
Yes.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you, Your Honor. Have a good day.
Court calls the case of the people versus Lisa Keebler.
Afternoon, Jan Uwe Daus with and on behalf of Ms. Keebler here for the first probable cause conference after her arraignment. Lisa, state your name for the court.
State your name.
Lisa Keebler.
Thank you.
There is a green sheet discovery, adjournment request in the file for ongoing discovery evaluation. This is really Mr. Shea's case, much more than mine, and he couldn't be here today.
Yeah, I understand that. Do you say how much time he?
He was looking for 3 weeks, March 12th.
3 weeks, March 12th. No objection. Probable cause conference then will be adjourned March 12th, 2026, 9 a.m. Bond in this case will continue. All right, thank you.
Very good. Thank you.
Court does call the case, people versus Ethan Jordan.
Afternoon, Your Honor.
And good afternoon, Your Honor. For the record, Orlando Simone, Student Legal Services. On behalf and with Mr. Jordan. Did you say your name?
Ethan Jordan. Thank you.
And Your Honor, we put in a request for a brief adjournment. I'm still looking for some additional discovery. Some body cam. Talk to Mr. Cook. We should be able to get that and take a look at it.
And Your Honor, we have that. It just needs to get to Mr. Orlando.
Got it. 12th work.
We're good with the 5th. If you prefer the 12th, we can do the 12th.
You want the 5th? What do you want? What day you want? I don't usually ask that. That's the 12th or the 5th?
I'll take the
Pick a date.
I'll take the 5th.
Thank you. You'll take the 5th. Yeah, you just got that. All right. March 5th, 2026, 9 a.m. All right.
Excellent. It's too big of an opening.
Yes, it was. Fine, we'll continue.
Served
Thank
it up
you.
nicely. Thank you.
Good seeing
Good
you.
to see you. Thank you.
Thank you. Court calls the case, people versus Haley Garcia.
We can get my client admitted into sobriety court. So we would like to adjourn this matter, what, 30 days? I think maybe 30 days.
Which court?
So, Your Honor, he lives on the east side of Detroit, so I was thinking either St. Clair Shores or Warren, because those are closer to him.
He's in Wayne County though, right?
Correct.
I need a green sheet filled out. I'll give you the adjournment. I'll adjourn this matter to March 19th. 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you.
I do have another matter. I don't know if you.
Bye.
I do have another case. Oh, no, wait. I do have another case. I don't know if you were, or should I be seated and wait?
How does that work usually? No, how
All right.
does that?
I'm sorry, Your Honor. It's
No,
been a
I've
little.
got another one here. I don't know. Did I change something, Marilyn? Okay.
I
didn't think so. Court does call the case People versus Joshua Steuben. And see, I knew it was going to be the next one, but I was going to make you go back there anyway, because I only had one case.
Deborah Schlossel on behalf of the defendant, Mr. Joshua Steuben. Your Honor,
State your name. sir.
Joshua Steuben.
Thank you.
Sorry, Your Honor, I'm a little off guard. Your Honor, we also would like to adjourn this matter out 30 days for the purpose of plea negotiations.
Any objection from the people?
No, Your Honor. Also, know there's some media that I need to get to defense counsel as well. We have that. I just need to make the meeting.
I said that one for the 19th.
That is correct, Your Honor.
March 19th, 2026.
Thank you, Your Honor. I will fill out a
9 a.m.
green form for.
Bond will continue. And I don't think you have another case because I don't have any more files.
No, I
to that
don't.
block. So you're good. I'll need a green sheet on both.
All right, thank you.
Your Honor.
So. Even when they're not here yet.
This attorney. Fire. Just expanded, tried to file the suit request late and I didn't talk. So I have not had contact with him.
Court calls the case People versus Francisco Joseda Lara.
And Assistant Public Defender, Chanel. On behalf of my clients, Judge.
I extremely apologize, Your Honor, for showing up late.
Your name?
My name is Francisco Andres Casal, right?
Your Honor, I know the court would like to address the bond violation first.
Yes. There a particular reason you can't test on time?
I'm sorry, Your Honor. I try to do it just with having kids and I'm in a busy life as a single dad. It's kind of hard to take track of the times, but I will be more on top of it if you give me another chance.
Did we set an order on this one? Or we just got?
We just got that yesterday, Your Honor. This is the first violation.
And Your Honor, I've spoken with Mr. Cazetta Loretta, and I asked the same question that the court did. He indicated to me that he thought that as long as he got the test in, that he would be fine. I told him that these time blocks in which he's supposed to test by.
I don't know what that meant. As long as he got a test in.
As he's supposed to test between 6 a.m. and 9 a.m. and he tests at 9:18 a.m. because the majority, if not all of these, are for late tests. I tried to look through every last one of them. I don't think that there were any. There were a few missed tests very early on in December.
I guess I'm unclear though as to why, if I give you 3-hour windows, you can't find the time in those 3-hour windows to test.
Your Honor, he explained to me that he has been extremely overwhelmed with his children, his work schedule, which is those are the different reasons that he's been testing late. Sometimes he wouldn't even have the device on him when he was at work or elsewhere. I told him that this is a very serious situation. I would say that the positive is that he has not had any positive tests. And I know that weighs a little bit because obviously the court has required that he test timely. I have spoken with him. He informed me that he's currently on probation out in Kent County in Kentwood. I did supply the court with another document. I spoke with his probation officer in Kentwood, and she states that he is currently testing with them 1 to 2 times weekly. He's doing ETG tests as well as it's a dipstick test is how she described it. And he's doing the ETG tests and it tests for drugs and alcohol. I have provided the court, I asked her to submit a write-up explaining the results of those tests. She did submit it to me. I forwarded it to his community corrections agent, and I furnished a copy to the court as well as the people.
When was that?
Today, Judge.
Did we get something from?
Yeah, it's in the file. And what you're gonna be ready.
Yes.
It's right here.
So, Your Honor, and I asked specifically, I know in the initial paragraph, she describes the type of testing that he's currently doing, but in the body of it, it does not say alcohol. She says that if it does not say he's positive for alcohol, then he has not tested positive for alcohol. And she has confirmed that all of his tests have been negative. He does have the positive THCs, but he has a medical marijuana card.
Justice has 2 failed to appear.
So the 2 failed to appear. He's telling me that he was in another court that date. I'd have to confirm the dates, but Your Honor, he did not start testing in our court until 12/12 is when he was required to begin his testing. So from the time frame that he's been testing with us, he has been very consecutive with his tests in Kentwood as well. And he has been negative for everything there, except for the positive THC, which he has the card for.
Can't seem to do anything on time. Why was he late today?
Your Honor,
Your Honor, I was late coming over here. I stayed out in Grand Rapids, so I had to pack my family up and I took off. And right 30 minutes before I remembered about my harassment test, so I turned around, ran home, did the test, submitted it. And I brought the apparatus with me just in case. I deeply apologize for the time frame, sir.
and Your Honor, typically the court has been very generous in allowing him to log in on Zoom. I think the court can remember when this.
All right, is all discovery complete?
Yes.
All right. People have their witnesses available? People have their witnesses available the 3rd?
We'll do our best, Your Honor.
Preliminary examination in person will be set March 3rd, March 3rd, 2026, 9 a.m. before Judge Perry.
Okay. Thank you.
Thank you. Bond will continue.
Thank you, Judge.
Thank you, sir. Court calls case, People versus Koisha Pipkins.
Mr. Pipkins is present on Zoom.
Ms. Pipkins, can you say
Yes, I
your
am.
name, please?
Yes,
State your name.
Koisha Pipkin.
Okay.
Koisha Pipkin.
One more. Just adjournment so I can reboot this.
Probable cause conference will be adjourned to. You had previous, did you just get into this? Or
Yes,
just
yesterday.
put up? Okay. March 19th, 2026, 9 a.m.
Thank you.
Bond continued. Thank you, ma'am. Court calls
Thank
case
you.
of People versus, you're welcome. Court calls case of People versus James Thomas.
Well, good afternoon, Your Honor. Raymond Cook with the people.
Afternoon, Your Honor. Dan Garrett on behalf of James Thomas. What's your name, Dan?
James Thomas. Thank you, sir.
Your Honor, we also just substituted in yesterday or the day before, would ask for an adjourned PCC, please.
All right, 12th or 19th, who better for you, sir?
19th, please, Your Honor.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, the people versus Francisco Cazeta, is it Laretta?
Assistant Public Defender, Shanazi Carey, I can really, on behalf of Mr. Caseta Loretta. Can I just check outside?
With this bond violation report, I doubt it's here, but you can go ahead and check if you want.
Doesn't look like he's here, Your Honor. I
I'm
have,
shocked. Go ahead, I'm sorry.
for the record, Your Honor, I have spoken with Mr. Caseta Loretta. He assured me that he would be here today, and we had what I thought was a very good explanation to provide to the court today for the voluptuous bond violation.
It's like 3 pages.
It is. He was asking to be on Zoom, Your Honor, and
Sure he was.
I told him that the court, I was not even gonna make that request because I knew it would be denied. He does live very far away. I would ask the court to pass.
He lives very far away?
Yes, he does, Judge, in Kentwood County. I don't know where that is. Grand Rapids, yep.
I knew that. I knew.
So,
Bench warrants will issue for defendant's failure to appear. Nice argument.
thank you.
Bond $25,000, cash surety. That warrant will issue immediately.
Your Honor.
I don't know why she looked disappointed. Did she really expect anything different? Court calls the case, People versus Lawrence Ransom.
Your Honor, reading for the people.
Assistant Public Defender, Shanazi Carey, I can do Your Honor.
Is Bishop responsible for getting your people here? No, is Bishop responsible for getting your people here? Because if he is, he's not, don't walk out on me yet. And continue with the streak, Mr. Gaddy.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Reed. Your Honor, I've reached out 7 ways to Sunday. I don't have any explanation.
Bench warrant, $10,000, cash surety. That warrant will issue immediately. Court calls the case, People versus Mapendo. Hereditary.
Judge Torture, Assistant Public Defender on behalf of my client who is on the way up, Judge.
Oh, okay.
Please state your name when you get to the podium. Say your name.
Mapendo, I see.
Right. Thank you, Judge. After turn to the hand of the bar. I've turned to the court at Green Sheet. We spoken to Mr. Childers about a resolution. We're very close to a resolution. We have a brief adjournment. I think we'll get this matter resolved.
Well, 2026, 9 a.m. bond continues.
Thank you, Judge. March 12th. Call.
Court calls case, People versus
Wait for that there. I'll get it to you.
Jalen Seal.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Steele. Your Honor. He is approaching, he's with my truck. Can you grab him? He is approaching.
Here?
He is here. He's in a room with Mr. Green from our office. Your Honor, if I might just have a second.
Your name, sir?
Joe, too.
All right.
Your Honor, we'd ask the court to set this matter for a preliminary examination.
Discovery is complete.
Yes, Judge. To the best of my knowledge.
People have their witnesses available the third preliminary examination in person. March 3rd, 2026. 9 a.m. before Judge. Fresh hour.
Thank you, Your Honor.
Thank you, Judge.
Bond, continue. Court calls the cases of the people versus Tasha Shiner.
Michael Gandy, Assistant Defender on behalf of Ms. Shiner, Your Honor. She's not here that I can find. She was released, it looks like on February 11th. There's a bond violation. I don't have contact information for her, so I wasn't able to reach her. I think she was up in Alpena, then got brought down here. It was released on the 11th, and I saw the bond violation yesterday.
Yeah. Bench warrant will issue. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Case people versus Charlene Smith.
Your Honor, Raymond Cook to the people.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender. Your Honor, I've called Ms. Smith's name in the courtroom and in the hallway
And what?
with no response, Your
No response?
That's
Shocked. You know what? I think she's with Miss Akinruby's class. It's got a bond violation also. So bench warrant will issue bond $25,000. Cash 26,830 before
March
Judge
9th.
Perry. Yes,
Thank you.
but make sure you contact 15th District Court probation.
Yes, sir. Thank you, Your Honor.
Bond in this case will continue.
Oh, Your Honor, if I may briefly address part of that bond. After speaking with my clients, my understanding that he's been on tether since November 25th of 2025 with no issue. He is seeking to have that tether removed at this time, if that's possible.
I'm not going to remove it if Judge, I'd leave it to Judge.
Just state your name for the record.
Matthew Smith.
Your Honor, we are requesting an adjournment in this matter so that we can have an opportunity to review some media. We also are asking, pursuant to the report received from
Where is your card?
I'm sorry.
Where is your card?
I think it might be in my backpack in the car.
I don't see on here where she's indicating that you have presented a medical marijuana card to her. Well, first of all, in regard to your request, I'm not going to change it because he's missing tests.
Your Honor, it was my understanding from reviewing the report that she's marking them as missed, but actually he's appearing but not able to provide a sample.
There are two things. One, so on December 16th, January 2nd, January 12th, January 22nd, and February 12th. The results are missed, but they are marked that he's unable or refused. On December 24th and on January 30th, it's missed, but not he just missed the test. Can you see if you can get through to Miss Dozier, see if there's a card?
Is. But I did talk to her this morning. She said she had it. Yeah, it should be in
Your Honor, if we could pass, he will either go look for it, or if you would like for us to stay here, we'll see if his sister is available to go into the car to look for his medical marijuana card.
That says yes, with an issue date of 5/8/24 and an expiration date of 5/8/26.
Okay, we have it.
Thank you.
He's good. All right, you want an adjournment on this?
Yes, please.
I'm not. We can change his testing to a swab, but I don't want any missed tests. Do you understand that?
Yes, sir.
I'll adjourn probable cause conference then to March 12th, 2026, 9 a.m. Bond will continue.
Hey, thank you, Your Honor.
Court calls case, People versus Danielle Stewart.
An Assistant Public Defender Jay Bellinger on behalf of Ms. Stewart, who should be in appearance via Zoom, Your Honor.
Hi,
Hello, what's your name?
Danielle Stewart.
Your Honor, we are close to a resolution on this matter. There's just some nursing licensing stuff that we need to check in on. So we were just asking for a little time to do that.
March 12th, 2026, 9 a.m.
Right.
Thank you.
Have a
Thank
great
you.
week without me.
It'll be hard. Thank you.
I know. You'll get through it.
Take care.
Thank you.
Court calls the case, People versus Lakrita Thompson.
As a public defender, Chelsea Virgil is with and on behalf of Lakrita Thompson, who is approaching. Thompson, please state your name.
Lakrita Thompson.
What are we doing?
Good morning.
We are asking to adjourn for Ms. Thompson to review her discovery and for a plea discussion. But also ask to address a bond condition when the court is ready.
Probable cause conference will be adjourned to March 12th, 2026, 9 a.m. Yes, as to bond.
Thursday. Your Honor, regarding bond, Ms. Thompson is on a scram tether currently, and she's asking to switch to a SoberLink device. She's having some health issues. She has a note from Trinity Health stating, due to the health issues with her legs, she needs to wear compression socks due to her varicose veins. She is on her feet all day at work. She works full time. Ms. Thompson,
That's what the medical indicates.
Right here.
yeah, so this note from Community Health states, so one states she was seen at the emergency department due to longstanding history of pain due to varicose veins. She needs to wear
This is from my doctor.
compression socks, and then
We
this-
will switch, that's all right. We'll switch her over to Soberlin.
Okay, thank you, Your Honor.
Her bond will continue. We'll prepare a new order. She can be switched over to the Soberlin testing list.
We appreciate that. Thank you, Your Honor.
Thank you.
You're welcome.
Court calls the case, People versus Willie Thorne.
Judge, court shall please to assist the public defender on behalf of Mr. Thorne, who I believe is on Zoom. Mr. Thorne, please unmute, state your name for the record.
Mr. Thorne, can you unmute?
My name is Willie Thorne.
Thank you.
Thank you, Judge. I believe Mr. Cook is going to speak to the complainant in this matter and let us know. Judge, I was going to adjourn it, but we just spoke to Mr. Cook. We're going to set it for exam and move it forward, Judge, if you don't mind.
Discovery is complete.
Come on now, Judge.
People have their witnesses available on the 3rd.
Do our best, Your Honor.
Preliminary examination in person, March 3rd, 2026, 9 a.m. Bond will or before Judge Perry. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the People versus Tootle.
Good afternoon, Your Honor. Raymond Cook for the people.
For the judge, torture officer, or defender on behalf of Ms. Tootle, Ms. Tootle would like her exam date, please, Your Honor.
She wants an exam.
Yes, Judge. To my knowledge.
Discovery to your knowledge is complete.
Yes, Judge.
People have their witnesses available the 3rd.
Do our best, Your Honor.
Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Freshour.
Thank you very much, Judge.
Bond will. The plea.
Oh.
Hello?
Hello, Mr. Umber, can you state your name?
Yes, Michael Umber.
All right. I have before me a plea form that indicates that the defendant is going to be pleading no contest to 2 charges. One of operating while intoxicated, second offense, a 1-year charge, and also count 4 of disorderly person, which is a 90-day offense. Upon his successful pleas of no contest to counts 2 and 4, counts 1 and 3 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well.
All right, very good. Sir,
Yes.
Can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God? You're going to
Turn the
have
volume up on my phone and I'm still having problems.
Okay, all right, let's do this then. I'm not gonna, if you can't hear me. If I set a new date, do you think you can get down here so we can get this done?
What's the date?
I can set it for next week or the 5th.
This courtroom sequence shows how quickly proceedings can shift from routine to serious when responsibility and accountability come into question. As multiple cases move forward, the judge maintains strict control, setting dates, accepting pleas, and ensuring each defendant understands their rights. But the tone sharpens when defendants fail to appear or violate court expectations, leading to immediate bench warrants and firm consequences. One moment stands out where an absent defendant's excuse falls apart after Bishop walks out, leaving the court unimpressed and unwilling to tolerate delays or avoidance. At the same time, other defendants who take responsibility and cooperate are handled more efficiently, highlighting a clear contrast. In court, respect for the process matters. Overall, this hearing reinforces a powerful reality. Courts operate on structure, not excuses, And when that structure is ignored, the system responds without hesitation.